All right. Again, a very warm welcome to this talk and discussion on how to interpret the Constitution. Dear members and friends of the America House and of the German American Lawyers Association, dear guests, thank you for tuning in. It is my honor and pleasure to welcome our distinguished guest speaker, Professor Cass Sunstein of Harvard Law School. Thank you so much for joining us from the East Coast and for taking the time to speak to us. And thank you also to Alexander Horn, who has kindly agreed to moderate tonight's discussion. How to interpret the Constitution is a question that is not only of great relevance to lawyers or legal scholars, it is a question that is closely connected to some of the most hotly contested issues in American politics and society today, including abortion rights, affirmative action, gun laws, as well as Donald Trump's eligibility to run for president in light of the 14th Amendment, to give just a few examples. So I'm very much looking forward to hearing Professor Sunstein's argument as to how to choose between different and conflicting constitutional interpretations. Before I hand over the virtual mic, two quick remarks to everyone in the audience. One, you are cordially invited to participate. Please submit any questions you may have via the Q&A or F&A function. They will be picked up in the second half of the event. And secondly, if after the discussion you are interested in reading the full version of Professor Sunstein's book, you can purchase it at a 30% discount. And we want to thank Princeton University Press for making that possible. We will be posting the discount code and information on how and where to order in the chat. And with that, I want to hand over to my colleague, Andre Pantel of the German American Lawyers Association. It is always a great pleasure to work with you. Thank you so much for co-hosting this event.
Good evening in the USA. Good evening to Germany. Dear Victoria, thank you for your kind introduction. I also extend a warm welcome to all of you on behalf of Deutsch-Amerikanische Juristenvereinigung, DAJV, to this event. Frankly, when Victoria asked me in November if we wanted to organize this event together, the decision was quickly made that we should. Professor Sunstein has been a leading expert in his field for decades, and the title of his book, How to Interpret the Constitution, is more relevant than ever in America in the 2020s. Professor Sunstein, we are delighted and honored to have you with us today. But now let's get started. For that, I would like to introduce you to tonight's moderator, our esteemed DAJV member, Alexander Horn. Alex is an attorney in Gibson Dunn's Frankfurt office. He's, positively speaking, an amateur in US constitutional law. During his LLM, he decided to jump right into the belly of originalism and the minefield that is US constitutional interpretation. His professor for originalism at the time was Stephen Sachs, who is now Cass Sunstein's colleague at Harvard Law, and whose theory of originalism is referenced in his book. With this background, we have undoubtedly made an excellent selection with Alex as our tonight's moderator. Alex, I now hand it over to you.
Thank you so much, Andre. We will start our event with remarks by Professor Sunstein, and he will speak for about 10 to 15 minutes, and then we'll start with the more interactive part of our event. I'll have some questions for him while you gather yours, and that's not to say that my questions are in any way more relevant or snappier than yours. I'll just give you some time to reflect on what you've heard, and then we can all discuss together. Professor Sunstein, take it away.
Thank you so much. It's a great honor to be here, and it's a particular honor given the time in human history that we now find ourselves in, And I'd like to say by way of preference that this is a time of celebration and maybe resolve. The German constitutional order, with its reference to human dignity, is a beacon throughout the world. The US Constitution, with its emphasis on liberty and separation of powers and freedom of speech, is also a beacon. And in a time when the idea of liberal democracy is under severe pressure in various parts of the world to speak about constitutional law in a way that is not only technical, but also inspired and a little awestruck is the right thing to do. Ideas of liberal constitutionalism have been born in large part in two nations, Germany and the United States. And for us both to be thinking about foundations and to be cheering achievements is very much in order in 2024. In the United States, all participants in debates about constitutional law, including those on the right on the Supreme Court and those on the left in the Supreme Court, are firmly committed to liberal constitutionalism, where the word liberal refers to the liberal political tradition and includes a commitment to the rule of law, to freedom of speech, to freedom of religion, and to, let's just say, some version of separation of powers. Having said that, issues that involve privacy, the scope of the equality principle, the nature of freedom of speech, the power of the president, the power of administrative agencies that implement law involving immigration or the environment or communications. All of these are in play, with fundamental disagreements both on how to resolve particular cases and also about method. We can broadly sort people right now in US constitutional debates into two categories: those who are originalists in the sense that they believe the original meaning of the Constitution is binding, and let's call the others living constitutionalists, who believe that the original meaning of the Constitution is relevant but not binding. Originalists come in various shapes. Some people are semantic originalists. They believe that the original semantic meaning of the words is binding. That's not a very controversial thing to say. Semantic meaning is pretty open-ended and allows for living constitutionalism. There are people who believe the original intentions are what matter, what was in the minds of those who wrote and ratified the provisions, and there are those who believe that the original public meaning is what matters. The original public meaning school, we might call it, is very much on the ascendancy. So let's call them the modern originalists. If you are an originalist, you will think that the abortion right does not exist. In fact, there is no general right to privacy. The right to freedom from sex discrimination probably doesn't exist. It's very hard to say that's consistent with the original understanding. And the free speech right automatically truncates. There's some evidence that on the original meeting, blasphemy laws were permissible. And it's pretty clear that the robust free speech principle that the United States now enjoys goes far beyond the original public meaning of the First Amendment. If you are a living constitutionalist, you might believe first that the Constitution should be approached in a way that improves democratic self-government. There are judges and scholars who think that. Then the idea would be the original meaning would not be binding. Within the confines of the text, the semantic meaning, we should approach the Constitution so as to promote freedom of speech, which is central to democracy, the right to vote, which is part and parcel of democracy, and those forms of freedom that are associated with a self-governing people. Think of that as the official creed of the Supreme Court under Chief Justice Earl Warren, and that is a view that many justices have held. Some living constitutionalists don't believe that approach is adequate. They think that the Constitution sets out majestic generalities, equal protection of the laws, due process of law, for the freedom of speech. And on this view, those majestic generalities should be given a moral reading, so that even if the Equal Protection Clause didn't originally forbid sex discrimination, the right moral reading of the Equal Protection Clause forbids sex discrimination. Even if freedom of speech didn't include, let's say, blasphemy or sexually explicit materials, the right moral reading might. So there are moral readers and there are democracy reinforcers. They are living constitutionalists and they disagree sharply with one another. Okay, the main submission I'm making today, and what I want to urge as the thesis of the book, is that the Constitution does not contain the instructions for its own interpretation, and originalists and living constitutionalists are not supported or rejected by the Constitution itself. There's no clause in the Constitution that says originalism is the right way or that says democracy reinforcement is the right way. So the only way to choose a theory of interpretation is external to the Constitution itself. The Constitution leaves this one open, and what it's leaving open is very fundamental. I want to urge also that given that the choice has to be made by us, the Constitution doesn't make this choice. The only way to make the choice is to seek what philosopher John Rawls called reflective equilibrium. That's a lot of syllables, but it's a pretty straightforward idea. It means that we have to bring our own judgments about particular problems and about general constraints in accord with one another. If originalism led to an amazingly good constitutional order, then I suggest we should be originalists. If originalism led to a constitutional order that Americans shouldn't be proud of, then we should reject originalism. Now that leaves a lot open. We have to figure out what originalism or democracy protecting theories of interpretation or moral readings would entail. But I suggest the search for getting our various judgments about racial segregation, freedom of speech, freedom of religion, the rule of law in some sort of equilibrium with one another, that's the only game in town. There's no other way to go. In my view, living constitutionalism prevails on that approach. It leads to a constitutional order that is worth our celebration rather than our kind of cautionary questioning. That living constitutionalism of one or another sort leads to a constitutional order that is a beacon for many people all over the world. Whether or not that conclusion is right, I want to insist on the main suggestion, which is that people of good faith are arguing what the right approach to constitutional interpretation is. They are liberals in the sense of the liberal political tradition. They are Democrats in the sense that they believe in self-government. If one or another side is losing the argument, it's because that side produces a constitutional order that deserves less celebration than the alternative. Thanks.
All right, thank you very much. I will try to assume the role of the late night host who shamelessly holds the book into the camera. I'm not sure if that's going to work, but not with the blurring.
It's a beautiful crisp cover. And it's
yeah, I know. I probably didn't really make the camera. I managed to read it in the last couple of days, and just to let my German colleagues know what they can expect when they have a look into it. What struck me was that what you just laid out as, let's say, the playing field of constitutional interpretation in the US is very succinctly narrated in the book. So anybody who would want to have like a broader overview of what people disagree about, that is an excellent way to start. Certainly something that I would have cherished to have when I embarked on on that journey. And there's something that German law books rarely have. There's very limited legal jargon in there, so it's, I guess, for anybody wanting to have a quick read, it's very easy to do so. So you don't have to be a constitutional scholar to enjoy it. And what I most liked about it is that it really encourages you to take your own approach or make your own approach to constitutional interpretation, and not hide behind a certain school of thought and just say, oh, I'm an originalist because I believe X. And that's what originalists say, but you really have to defend your view. And you encourage the reader to define his or her fixed points in constitutional theory, or in terms of cases, what the outcome of these certain cases are. I will not spoil your fixed point, which you mentioned in the book as well. But maybe to jump on the topic of fixed points, how can you bring those fixed points in, or square them with the goal of making a better constitution? Because fixed points will undoubtedly vary. There will be, I would probably say, some people will aim to have the constitution be a beacon of freedom. Others will aim the constitution to prohibit a right to abortion, and that will be their main goal. So what, in your view, would be the deciding factor on what is a better constitution rather than a worse one?
Okay, so let's talk about political philosophy first, with your indulgence. How do we decide what justice requires? How do we decide whether we should be utilitarians or Kantians or something else? How do we figure that out? There's nothing intrinsic in, human life that answers this question, and we have to answer it. And what John Rawls, following Aristotle and Kant, can be thought of in the same way, thought we have to think what we hold most dear and how that squares with various theories of justice. So we might think whatever theory of justice we have, it can't allow human slavery. Or whatever theory of justice we have, it can't involve, let's say, purposeless torture. Or it can't allow rape. And then we have to think, what is our account that fits with those? And we might think that, well, people should be treated as ends, not as means, a Kantian idea. That might push us toward Kantianism. But it might be that Kantianism would lead us to say you can't have white lies, like you can't tell people they don't look fat in that outfit, even though they do. And then we might think, well, Kant, and this is how we do political philosophy. And I think Rawls was correct on that. Now, let's suppose we're thinking about a constitutional order. It could be the German, it could be Canadian, it could be the United States. We are bound by the Constitution. So if there's nothing in the Constitution that plausibly creates, let's say, a right to against animal cruelty, it doesn't give cows the right not to be treated cruelly, then you don't have anything to do. There's nothing in the Constitution that protects that right. But suppose you have a word like equal protection of the law or the freedom of speech. You might think that any conception of the freedom of speech that allows the government to suppress speech on the ground that the government believes it's dangerous leads to such a illiberal or plausibly fascist or something government that it's not tolerable. And if you think that, then a theory of interpretation that leads you to that truncated view of freedom of speech is in deep trouble. It might be that it has any number of other virtues, so you'll bite that terrible bullet, but you're not going to bite a lot of bullets. Now, if there's someone who says, I want a constitution that allows the government to forbid freedom of speech if the speech is dangerous, then there's nothing you can say to them except really, and then talk with them about it. So if someone says a constitutional order that allows abortion to occur is intolerable to me, then that's a point, and they might not agree with you on your theory of interpretation. And it may be that we can't get in accord on theories of constitutional interpretation. But now, thank goodness, we know why. It's because different people have different fixed points. And that's not something to weep about. That's part of, let's call it, the rule of law meets pluralism. And I'm very glad the rule of law meets pluralism. We don't want them not to meet.
All right. And once you've defined your fixed points, how would you then go about in interpreting certain amendments of the Constitution or some provisions that were not originally part of your fixed points, or that are not defined by your fixed points? I noticed that the fixed points you mentioned for you in the book are rely heavily on substantive due process topics, some commercial clause topics as well. But for example, the issue that Victoria raised at the very beginning of our hearing, would Trump be disqualified from running for president under the insurrection clause, was not one of your fixed points. And how would you go about then interpreting that?
Okay, so the fixed points are, this is sounding a little more exotic than it needs to. The fixed points are a way of choosing a theory of interpretation. So should we be bound by the original public meaning? Suppose we lived in a constitutional order, call it Italy, just making it up, where the original public meaning of the Italian Constitution leads to an extraordinarily good constitutional order. It's by what, let's just leave bracket what that means and just let's insist on the point. Then Italy should be originalist. That would be a very good thing for it to be. And then the Italian judges who are committed to originalism would approach novel questions by reference to the original public meaning. Or let's suppose there's another country, let's call it Argentina, where the original public meaning isn't so great, but the Constitution interpreted in light of the abstract goal of democracy, that's a fantastic Constitution for Argentina. Then that's what they should do. And then that's the theory of interpretation they should bring to bear on particular cases. Now, the Trump issue is extremely interesting for any number of reasons. To me, for present purposes, what's most interesting is that everyone seems to be approaching it in the first instance, as a question of original meaning. And I believe originalism is a good way to approach the question whether a president can be impeached. So I favor the original public meaning for impeachment. And that's because the original public meaning with respect to impeachment, it's terrific. It's really good. It defines high crimes and misdemeanors in a way that's narrow and focused on abuse of power. And if we don't use the original public meaning for the impeachment clause, then we're in political quicksand, where people can be impeached just because the House doesn't like them. And what kind of democracy can you have if the president gets impeached because the House doesn't like the president? That's not conducive to stability. So it might be for the insurrection clause, originalism is the right way to go. There's a theory to that effect, but some people would not agree with that. One view, let's take this as a cautious view, which is extremely interesting, which is that any legal tradition has in it background principles that have names that are plausibly brought to bear on constitutional meaning. You might have a background principle that says there's a rule of lenity, where in many nations, if a criminal statute is unclear, the criminal defendant gets the benefit of the doubt. That's not because we like criminals. It's because we don't want people to be in jail or subject to criminal punishment by surprise. So the idea has to be clear. So the rule of lenity isn't in at least the constitutions I know, but it's a background principle that many liberal democracies invoke. And that might be, I'm not sure whether it's right to say part of originalism or a qualification of originalism.
Okay, so I guess from your answer, then you would have a splintered method of interpretation. You would be a living constitutionalist in most things, but where originalism would fit better, then you would put that in there.
Yeah, and there's nothing really exotic about that. So our free speech tradition in the United States, it's not originalist at all. It's developed in a case-by-case way, which was actually very much informed by the world's experience in the 1930s and 40s, with the key sentence coming from Justice Robert Jackson, who's the prosecutor at the Nuremberg trials, who on the court says, compulsory unification of opinion achieves only the unanimity of the graveyard. If anyone on this call wants to remember anything from this hour, I vote for that. Compulsory unification of opinion achieves only the unanimity of the graveyard. It's the most powerful sentence, I think, in the history of the American Supreme Court. It speaks to the world today as well as the world back then. And what I want to say is that Jackson's opinion, those who try to exterminate dissent end up exterminating dissenters. He said it better than that, but that was the music. That's not originalist. That doesn't come from the original public meaning of the Constitution. In fact, that's a theory of freedom that the founders of the Constitution probably didn't, the authors and ratifiers probably didn't endorse. It's broader. So our free speech tradition isn't originalist, but with respect to the right to possess guns, the Second Amendment right, the Supreme Court has been originalist. And whether or not we love that, it's understandable that there's kind of originalist track for speech and non-originalist for guns, because the gun issue really came to the court only in full form in 2008. And what's the court going to do? It doesn't have a tradition of development. It just has a question. And whether or not originalism in the form the court has embraced is right, or whether it's been applied correctly, these are both fair questions. But the idea of originalism for some clauses, not for others, that's built into our practice.
I guess for a German lawyer, the idea that your method of interpretation changes with regard to the article of the Constitution that you are interpreting is a little bit uncomfortable. We would love to have a fixed theory of interpretation that we can follow and then hide behind it with our psychological fallacies that everyone has in reaching a decision. And I guess our legal history has instilled that in us, that we have four methods of accepted interpretation, and everyone obviously applies them differently and has different views on hotly contested issues, but we would always say we apply the same method of interpretation in the end. And I guess maybe in a way that's a little bit dishonest because we don't reveal that we are kind of, if we have already reached the conclusion of our interpretation and then try to justify it in a way that fits the four accepted methods.
I have a thimbleful of knowledge about German constitutional law, so I want to be very, very cautious here. But my guess is that careful interrogation of method in Germany would reveal some surprises.
Yeah, we definitely have originalist approaches in German constitutional law. It's just on the very unsexy topic of federal competence regarding who can legislate what in the federal state. Is it the federal government or the federal states that can legislate on an issue? And there our Supreme or our Constitutional Court is very clear that we would always look to the original meaning of original public meaning of or maybe even the original intent of the legislator in that regard, because we would favor clarity over correctness in that sense. So just the competences are clearly divided in our federal state, and that is more or less the only option, or the only incident I know of that our Constitutional Court has fervently opted for such a historical interpretation. There are obviously numerous instances where history has crept in and has been used to justify a certain result, only then with maybe the dissenting opinion jumping on history and reaching a completely different result based on the history.
Let me be a little more polemical, maybe. What I try to do in the book is to give, it's a very friendly, genial book, to give a charitable account of multiple points of view. And the book is more, the author, yours truly, is more enthusiastic, or in the sense of open to originalism, than I was when I started. But it must be noticed that as practiced, the connection between the original public meaning of the Constitution, as understood by those who are originalists, and the current views of the Republican Party is uncomfortably close. So let's just say with regret that if it turns out that the original public meaning of a constitution from long ago maps on very well to the views in 2024 of the Republican Party, then we should think something is going on that is concerning.
Yeah. There's one question in the chat about updating the Constitution, and I know from watching your talk at Harvard Law that was one of the first questions that was asked in the auditorium there, and you said how often a Constitution is amenable to change and how easily it can be changed has nothing to do with which method of interpretation we should choose, and given the unique circumstances in the US with Constitution that's over 200 years old, yeah, that's a fascinating idea, because you're basically stuck with what's in there, and it's almost impossible, I guess, to have an amendment right now in whichever way possible. Knowing that the Equal Rights Amendment was shut down in the 70s, which would have enshrined the legal equality of men and women in the Constitution, and it's not in there. Would you hope that something like an update of like the most important fixed points would happen, even though that is very unrealistic?
Okay, let's talk about the word change and update. In 1950, racial segregation in the United States was constitutional and widely believed to be constitutional because it was. Now everyone agrees racial segregation is unconstitutional. That's unanimous. In 1960, discrimination on the basis of sex was believed to be fine, no constitutional problem. In 2020, actually before then, sex discrimination is no good. Freedom of speech was a really little thing in the early part of the 20th century. In fact, maybe it was a really little thing into the 1950s. It's really big now. There was, in the early part of the 20th century, a prohibition on minimum wage and maximum hour laws. They're now completely fine. Freedom of religion looks very different now from how it looked 15 years ago, and 15 years ago it looked very different from how it did 30 years ago. There's a right to same-sex marriage now. That would have been preposterous. There's a right to individual possession of guns now. That would have been preposterous in, let's say, 1995. So do you see where I'm going? The notion of changing is built into the system because interpretation leads to different under specifications of what rights and institutions entail. So there's a lot of change in that sense. I think what you're asking about is formal constitutional amendment, which is very, very difficult. After the Civil War, there were plenty, but in the last 50 years, not much. It's really hard. Whether that's a good thing or a bad thing, it's very difficult to say in the abstract. We'd have to make a projection about what more frequent constitutional change would lead to. And for those who are risk averse, like yours truly, there's an absence of tears about frequent constitutional amendment.
Yeah. Let's see. We have another question from the chat. Yeah, there's the question: can the concept of a living constitution lead to unlimited interpretation in the sense of judges running wild? That is certainly one of the the issues that originalism raises and why originalism came to be. But what's your view on that, and how would you constrain your own living constitutionalism?
Okay, so originalists can lead to a lot of disagreement and diversity. So does the Constitution forbid affirmative action? Originalists disagree sharply on that. Does the Constitution guarantee of individual right to possess firearms? Originalists disagree on that also. So A, history is often less clear than is hoped for, and B, people read history often in a way that fits with how they would like to read history. I like the way the question's phrased. Can the concept of a living constitution lead to unlimited interpretation? Sure, it can. In any nation, that would be unlikely in the extreme. Judges are appointed through a political process. They reason from precedent. They live in society. So the idea that the Constitution gives every person a right to fly or a right to have the most expensive lunch and dinner ever every night, that would be shocking to see. So we need to specify what living constitutionalism is. On one view, the Constitution, Justice Stephen Breyer defended, Constitution should be understood by reference to democratic aspirations. That could lead to unlimited interpretation, but it would be very surprising. It's more vote, speech. For other things, let the democratic process do a ton. And contrary to democracy and the rule of law, well, if you had a living constitution whose life was defined by reference to democracy and the rule of law, then by definition, that would be great from the standpoint of democracy and the rule of law. If you had a living constitutionalism which was opposed to democracy and the rule of law, then we'd have a big problem. I'm not aware of anyone who has a theory of living constitutionalism that despises democracy and the rule of law. People who despise the democracy and the rule of law have other things to focus on than living constitutionalism. I will say something consistent with the question, though, that's going to be a little more sober than what I just said. Historical work on the rise of fascism in Italy and Germany finds a very big difference between what the judges in the two countries did. The Italian judges were very literal and textual, and that cabined the power of Mussolini. The German judges, by contrast, were much more purposive and kind of like, a little like living statutory interpreters, and that was less of an obstacle. And I think it's a jarring example because many people who are kind of liberal in whatever definition tend to like more purposive approaches, but under some circumstances, textualism, literalism has some virtues.
You reference in your book that there's also progressive originalism, and that could, in itself have consequences that a living constitutionalist could also reach, and that wouldn't be so restraining as proponents of originalism often hope it would be. Could you maybe highlight that point and the point you made on Ketanji Brown Jackson's argument in I guess it was the Students for Fair Admissions case against Harvard?
Okay, so this is a great question. Thank you for it. So there are two kinds of progressive originalists, and let's understand the word to mean they're committed to originalism, but they lead to results that progressives or the left of center welcomes. And I say there are two kinds. There are some left of center originalists who seem to me like advocates for a cause rather than like historians who are just trying to figure out what the history reveals. And I say this with admiration for their diligence, but with awareness that the cause that they're for is not obscure and is kind of leading their efforts. So there are some progressive originalists with progressives, with the word progressive in very big, bold letters, large font, bold letters, and originalists a little smaller. And originalism is there being used for progressive ends. And they're like advocates, and they're good at history, and they mold it to their end. They're writing a brief. Then then there's another group of progressive originalists, let's call them, where originalism is in big, bold letters and progressive is in smaller letters. And I confess I admire them more because they are historically attuned. They don't care what the history produces, but they learn that the history often produces progressive results. And it's not like that makes them smile or grimace. It's just this is how it turns out. There's a book called The Original Meaning of the 14th Amendment by Evan Bernick and Randy Barnett, which is, I think it's a terrific book. The authors are committed originalists, and they find that the 14th Amendment, understood in a historically fair way, produces a lot of left of center results. Not only, but a lot of them. And that book I found extremely instructive. And whether the authors are happy that the results are left of center, right of center, who knows? They're just trying to figure out the history. Now, my own view is that the original public meaning too often leads to intolerable results and would lead to an inferior constitutional order in the United States. So we shouldn't be that. That's my own view. And the fact that racial segregation by the states, it's very difficult to show that that's inconsistent with the original public meaning of the 14th Amendment. And some people have tried. My view is it's very difficult historically. Even if they can meet that very hard challenge, to say that the Constitution forbids racial discrimination by the national government, that's really hard to say on originalist grounds. There's no equal protection clause applicable to the federal government. So you'd have to say something in the original Constitution forbids the federal government from discriminating on the basis of race, sex. And that's, people have tried, but it's very hard. And I say that's not a problem for our Constitution. That's a problem for the originalist method, that it leads to a set of results that are deeply troubling. Now, it's tempting to say at this point, as some people have said in skeptical reviews of my little book, they say this is all too result-oriented. You should choose a theory of interpretation on the basis of something other than the results that it yields. The theory of interpretation has to precede the judgment about results. To that, I say, good luck with that. There's nothing in the Constitution that tells you what theory of interpretation to choose, and how are you going to choose it, aside from asking what kind of constitutional order does it produce? And I mean this is an imperialistic claim. I mean this claim about how to choose a theory of interpretation to apply in every nation on the face of the earth that has a constitution, except if the nation has a constitution that specifies the theory of interpretation inside the document. And I suggest that if we interrogated German constitutional law, and I say this with keen awareness of how little I know, that something like a judgment of this kind is being made. And if there are 4 approaches to interpretation, there's reason for nervousness. In cases of conflict, what do we do? Which has priority? And it may be that one or another approach, or maybe all 4, are incompletely specified. So the identification of what it particularly entails involves some other work, which is probably in the general domain of trying to figure out what makes the system good.
Yeah, so just to clarify, they're not competing schools of thought as originalism or living constitutionalism would be. There more add-ons that you would try to follow. So the first one is pretty easy. It's just having a look at the wording of the clause and then saying, okay, we try to figure that out, the semantic meaning, and then you look at how the provision is embedded into the law, the constitution, and more generally, you have to look at the drafting history, and then maybe at the purpose behind it. Those are generally the 4 accepted ones, and you can weigh them differently in your approach, but you would try to kind of tick all of the 4 boxes when you are in law school and try to show that you know how to interpret the law. But that, since everybody is using the same tools, it kind of cloaks that people have different, or want to have different outcomes that they try to justify with it. Maybe a follow-up question on the progressive originalism issue. Would you think that, as you said, writing a brief with the progressive originalism in mind, or tailoring it to originalist arguments, is that anything that could bait the judges and the justices of the Supreme Court at the moment into accepting an argument, or would you think that they would, even though it's an originalist argument, always reject it on the ground that the result isn't welcome to them?
I don't know the answer to that question. That you have, some number of originalist justices. Okay, let's get a little fancy here, shall we? Suppose you learn something new about what the history entails. There are 3 things that might happen. You might think, oh, I was wrong and I'm sad and I have to come out with a result that I wish I didn't have to, but I've learned. Like, what if you learn something about biology or large language models? You might just learn and then you shift your view. Okay, the second thing you might do is say that, given my prior conviction, the burden of justification is very heavy on the lawyer to get me to be dislodged, and it's just really hard for them to do that. And I'm not going to. So to get me to believe that dropped objects don't fall, or that dogs aren't good, that would be very hard. And that's because I'm being a good Bayesian, meaning I'm updating given my prior. And if someone shows me a dropped object that doesn't fall, I'll say they're playing some kind of trick. I don't believe it. And so some of the justices, as Bayesians, as we all are, might think you've given me some history that suggests something preposterous, and I'm listening to you, but I'm not going to yield. I'm not going to believe that dropped objects don't fall. So there's a change in view. There's a refusal to change in view because the prior is so strong. And then there's motivated reasoning. So if you give me evidence suggesting dogs are bad, I much love dogs, as you might have noticed. In fact, my Labrador Retriever he deserted me. He was here just a moment ago. I have 2 Labrador Retrievers in the house. If you give evidence suggesting dogs are bad or something, I'm strongly motivated not to believe that. So I would dismiss it because my reasoning is result-oriented, not Bayesian, not updating, just very resistant to it. And then I could be dismissive of the evidence you give. So for a lawyer who tries to convince, let's say, a right-of-center originalist that the original meaning of the Constitution actually is pro-affirmative action programs, these are the 3 possibilities. I hear you. I agree. I'm sorry for my country, but I get the history. Second possibility, that's so unlikely, I'm not going to believe it. Bayesian. Third, I'm motivated to oppose it, and therefore I'm going to dismiss it.
All right. We have another question from the chat. I guess regarding the criticism of your book that it's too much result-oriented. Is there any research that you know of that backs the claim of the criticist up that interpretive methods shouldn't be result-oriented in any way, or cannot be?
Well, the only empirical book I know is on this is Frank Cross has a book called The Failed Promise of Originalism, which shows that originalism turns out to produce results that fit with the political convictions of those who practice it. That's regrettable for originalism. Okay, I don't think that's a direct answer to the question. Suppose you are okay, so we need to introduce one other approach. There's a guy named James Bradley Thayer who believed that the justices should uphold legislation basically unless it's clearly unconstitutional. So the violation has to be unambiguous. Some justices, including Oliver Wendell Holmes, have been Thayerians, and Holmes basically invalidated almost nothing, including things he hated. So Holmes was committed by his interpretive method to produce results that in particular cases he didn't like at all. That's an example. If you are a democracy reinforcing type, you might lead to think that abortion rights don't exist because there isn't a democratic justification for them. And John Hart Ely, the best theorist of democracy reinforcement, thought exactly that. To do research on whether constitutional interpretation is an ex ante mechanism for interpretation, it's very hard to know how you'd approach that question. And so the best I can do is to give examples of justices whose conclusions they regretted, but their method entailed.
And then we have 2 questions regarding the Second Amendment, which is always a pressing issue in Germany, looking over the pond, and in awe and in sorrow, seeing what is happening in the United States day after day, with guns in schools. People are asking, how can the originalist majority square originalism with allowing modern day guns?
I think that it's a great question, and I think it's not as rhetorical as it might seem. So how can an originalist understand the First Amendment to apply to the internet or to television? There wasn't an internet or television. And the answer is that we have to figure out the nature of the right. And if the right to free speech entails, let's say, a right to protection against censoring people's words, or let's just say words, because the government is endangered by the words, then whether it's on the internet or television doesn't matter. The level of generality of the original meaning resolves that. The Second Amendment, it's hard, but we have to do something similar. And the court has said that there's reasoning by analogy, where we look at whether it's analogous to the thing that was protected. And that's very controversial to figure out how that works. But it's not clear that originalism fails if there's a reasoning by analogy that attempts to map a new weapon, let's say, onto an old historical context, just like mapping the internet onto the world of newspapers.
All right, and then we have one further question regarding a particular case, Allen versus Milligan, regarding gerrymandering in Alabama, which was decided in June last year. And yeah, the question is about what method of interpretation drove the opinion.
The majority was pretty much a stare decisis opinion. And one thing that's quite remarkable is that originalism is new. That's itself, I think, a challenge for originalists. It is new, and that the cases that the court is basically reaffirming there were not originalist cases. They were more, I think, democracy reinforcing cases.
Great. Are there any further questions from the audience? I think we tick every question in the chat so far. I guess if there isn't anything else, I would think that we can also let people enjoy their night.
And keep in mind, if we would, if I may say as final word, a joint celebration for Germany and the United States of constitutional democracy.
Yeah, thank you so much. It's been a great discussion, absolutely worthwhile, and a true highlight to the start of the year, I would say.
Absolutely, I can only echo that. Thank you so much, Professor Sunstein, for sharing your insights, for sort of introducing us to the nuances of constitutional interpretation in the US, but in a way that is also accessible to non-lawyers, is at least what I felt as a non-lawyer. And thank you, Alexander Hahn, for moderating this discussion. And thank you to everyone in the audience for your absolutely thoughtful questions and for interacting with us tonight. Andre Pante, is there anything you would like to say in closing?
Couldn't agree more. It was a splendid and horizon expanding event for many of us. And special thanks to our speaker for dedicating the time, for our exceptional moderator, Alex, our partners at America House, and last but not least, to our engaged audience. Yeah, we hope to see you again soon at one of our upcoming events. Yeah, all the best. Thank you.
Absolutely. Thank you so much, and have a good evening, everyone. Bye-bye.
Bye-bye.
Bye-bye.